大家好，很高兴跟大家相聚在彼岸国际9月6日的移民分享会上。我是彼岸国际今天活动的主持人 James。今天呢，我们非常感谢大家的参与。我在活动开始的时候呢，也和大家分享一下我们本次活动的目的。我们在近期呢，发现移民局在审理829阶段的时候呢，会重新翻看申请人的资金方案。如果526获批的情况下，移民局依然会要求申请人补充说明资金方案。甚至因为资金方案的问题，请大家静一下音哈，谢谢。而拒绝申请人829的获批。我们今天邀请的两位重量级嘉宾呢，就在为此事和移民局协商沟通，并且拿到了移民局最新的评判审理标准。借此机会呢，我们也让两位行业专家们为大家分析和解读。那如果您有任何想咨询了解的内容，也欢迎您在我们的聊天窗口进行留言。那么接下来我将为大家介绍一下今天的第一位主讲嘉宾，John Patrick Pratt。Pratt 先生是 Kurzban、Tetzeli Pratt 律师事务所的合伙人。Pratt 先生被佛罗里达州、纽约州以及哥伦比亚特区的律师协会录取，他会被录取进入美国佛罗里达南区联邦地区法院、美国佛罗里达中区联邦地区法院、美国哥伦比亚特区联邦地区法院、美国第11巡回上诉法院、美国第9巡回上诉法院及美国最高法院。不好意思，我可能刚才说的这个内容没有听清哈。现在大家可以听到我的声音吗？
可以。
哎，好，谢谢。不好意思啊。对，然后我们第二位演讲嘉宾呢是 Edward Ramos，毕业于耶鲁法学院，是 Kurzban、Tetzeli Pratt 律师事务所的合伙人。Edward 的职业重点是在联邦法院对移民相关案件的进行诉讼。他以帮助客户提供不同种类的签证移民申请，如亲属类的签证申请。以及 H1B 和 I-140的申请，以及 EB-5签证申请、I-526和 I-829。Edward 的多起案件均为全国性集体诉讼，他代表美国律师协会和移民权利组织，在美国最高法院提交了数份状书，其中包括最近代表 EB-5区域中心和美国移民投资者联盟提交的状书。那此外呢，Edward 还协助客户处理美国移民局、移民法庭和移民上诉委员会等行政移民机构的复杂事务。Edward 对移民法充满了热情，并且喜欢挑战诉讼新颖和复杂的一系列的问题，以帮助客户实现他们的移民目标。那在会议开始之前呢，也请允许我简单为新朋友们介绍一下我们彼岸国际。彼岸国际是荣获美国证监会私募资质批准的房地产金融和投资移民跨境资产管理平台，专业为全球投资并购的企业和个人定制合规安全的海外投资配置方案。我们在美国发行了近30余只房地产基金，管理资产规模达到3.5亿多美元。我们在美国、香港、北京、上海、深圳、新加坡、加拿大、欧洲等多个国家和地区设有分支机构。我们除了在美国有非常强大的团队之外呢，我们的员工和办公室也是遍及了全球5个国家和8个城市。我们也非常欢迎您来参观我们的办公室，和我们一起沟通交流。那我们的团队在不断壮大的同时呢，彼岸国际也在进行实习生精英计划。我们会为在校和刚毕业的学生们提供实习岗位，帮助学生们达成自己的职业规划。我们在提升品牌价值的同时呢，也非常愿意和积极的承担社会的责任和义务。我们也非常欢迎年轻的精英们加入我们，与我们共同成长。那么在此呢，我也很荣幸的向大家介绍一下我们24年彼岸实习生项目。我们今年的实习生不仅面向在校的大学生，也为高中生提供了这次宝贵的机会。我们设计的1至3个月的房地产金融实习计划。那在这个项目中的话呢，实习生将在专业导师的带领下，了解美国的房地产投资、宏观经济、风险评估等知识领域。那加入我们，探索未知，锻炼实践，为自己的未来增添更多的可能性。但是由于名额有限，大家报名又非常踊跃，所以我们目前的实习生项目也只面向我们已投资的客户开放。 如果您对我们的北美暑期实习生项目感兴趣的话，也欢迎您联系您的彼岸专属顾问。那会议期间，如果您有任何疑问或者有任何想分享的内容，可以在我们的聊天窗口进行留言，我会将大家的问题进行记录。主讲人们会在问答环节为大家进行解答。非常感谢大家。那么时间不多耽搁，有请我们今天的主讲嘉宾 Pratt。Hi, Attorney Pratt. You can turn on your microphone and present your presentation. Thank you. And I can help you with the slides so everyone can see the translation.
Perfect. Thank you. So actually, first, this is Ed Ramos. I'd like to take this opportunity to thank Beyond International for inviting John and I to speak with you all this evening on the issue of source of funds, and in particular, how trends in how USCIS is moving to adjudicate source of funds issues at the I-829 petition stage. So I'll be taking the lead on this short presentation that we have that summarizes some of the things that we've learned in recent months about this new shift in the agency's policy and practice. And at the end, we'll save quite a bit of time for question and answer. And John will join me for that portion in responding to questions that you may have. There's a couple of things that I just need to say right off the bat. One is that we're not offering any legal advice during this meeting. So this is simply to share with you some of the findings that we've made, but please don't construe anything that we say as legal advice. And the second thing is that during the question and answer phase, we can address any case-specific questions. So we're happy to talk generally about policy, about trends, about any of the matters that we discussed today on the call, but we cannot answer case-specific questions. But we'll provide our contact information. It's at the very end of the presentation. And if you have case-specific questions, you're of course welcome to contact us, and we could discuss possible individual representation over email on a one-on-one basis. So with that, next slide, please. So let me just explain a little bit about our firm. We're a firm that does a couple of different things. One of our practices is immigration, and we're based in Coral Gables, Florida, but we have clients all over the world, and we have quite a few Chinese clients, particularly in the EB-5 space. Our firm has quite a bit of experience in the EB-5 arena. The founding partner, Ira Kurzban, litigated some of the most important cases in EB-5, including the first precedential decision from a circuit court on EB-5. And that was back in 2003. And we've been handling EB-5 matters throughout, basically the entire existence of the EB-5 program. We also do other areas of law. We have a personal injury practice that's run by a different set of attorneys in the firm. But we also do work beyond EB-5 as well. We're kind of a generalist immigration practice in the sense that we handle complex cases that arise in all contexts of U.S. immigration law. Okay, next slide, please. So a lot of the findings that we're going to be sharing with you today come out of work that we've done using a law called the Freedom of Information Act. And this is a U.S. law that allows any member of the public to find out or to request records from the government. This is a very powerful law that allows for uncovering internal policy, internal practices, and matters that the agency doesn't voluntarily make public. And we've collaborated with IIUSA, which is the leading trade organization that represents regional centers, to make requests of USCIS on important areas in the EB-5 space. And everything that we've uncovered through our FOIA litigation with IIUSA is posted up on our website, and I put the link there in the slide, and we make it available to the public. So anyone can go and see what we found and, we make it available to attorneys and to the public at large, in case people want to take a look for themselves and see, what we've uncovered through these lawsuits. The first lawsuit that we did on the Freedom of Information Act was really aimed at uncovering what was happening with currency exchanges. So as many of you may have heard, back in around 2017, immigration lawyers started seeing a new trend of USCIS issuing requests for evidence and notices of intent to deny in cases where investors used currency swaps, which are sometimes called informal value transfers. So, and this is an issue that's particularly important for Chinese clients because of the currency restrictions that the Chinese government puts on exports. And all of a sudden, USCIS started cracking down on cases where people were exchanging money through a third party where the money would not leave China. It would be exchanged internally within China, and then the third party would use US dollars that were held outside of China to transfer the funds to the US. And so the first FOIA litigation that we did with IIUSA was aimed at really uncovering, where did this policy come out of, and how was the agency treating this internally, because they were not really even admitting that there was any change in policy. And since that lawsuit, we've filed other FOIA requests and are pursuing other FOIA litigation, most recently on the government's practice of going after funds from what the government deems unlawful entities, which from our experience and based on some of the documentation that we've uncovered through this Freedom of Information Act litigation, includes Chinese companies, Chinese technology companies that the government is focusing on. And so we'll discuss this a little bit later in the presentation, but we wanted to try to really uncover where this policy came out of, what is the policy of the government with respect to money that's sourced from Chinese tech companies and other companies that the government has zeroed in on. And we're in the middle of that litigation now, and hopefully we'll be posting more materials to our website and posting our analysis on LinkedIn and other platforms. Next slide, please. So before I get into the nitty-gritty of what we've uncovered through the FOIA, I wanted to put this background information out there because it's important for some of the discussion. So in the United States, there are really three layers of law and policy. So at the highest level, we have statutes, laws, and those are the laws that Congress passes and the president signs. And those are, basically the core foundation of the U.S. legal system. Underneath statutes are regulations. These are essentially laws that the agency promulgates. So these are not laws that Congress passes, but they're basically laws that the agency itself puts out there through a formal process that interpret the statutes and provide more specifics on how the agency is going to apply a specific program. And then underneath regulations, you have basically internal memos and internal policy and other what we call sub-regulatory guidance. And this includes the USCIS policy manual that's posted online. It's an official set of policies, but it didn't go through the same formal process as the regulations did. And also, internal training memos, internal guidance that supervisors might issue to line adjudicators that are the ones sitting in an office looking at your I-829 petition or your I-526 petition. And the important thing for our current purposes is that only statutes and regulations carry the force of law. The sub-regulatory guidance is important. It's important for lawyers to know and for investors to know because it affects how the agency processes cases, but it isn't the law. And if you get to a real court in the US, that sub-regulatory guidance cannot override a statute or a regulation. So that's just some background that's going to be important later in some of our discussion on source of funds at the I-29 stage. Okay, next slide, please. So applying what we just learned in the, as a general matter, for source of funds in the EB-5 program, there is guidance at all three layers of the hierarchy. At the highest level, after the EB-5 Reform and Integrity Act of 2022, we actually have a statutory definition of what capital means. And that definition includes language that prohibits capital sourced from through unlawful means. And there's a whole section of the EB-5 law. It's at INA 203B5L that explains now all of the evidence that has to be submitted as part of an I-526 or an I-526E petition. But that set of laws only applies to new investors that are making their investments and filing their petitions after the EB-5 Reform and Integrity Act. For investors that made their investments before 2022, there actually is no statute that defines what capital means or imposes a lawful source of funds requirements. Those requirements come from the regulations. And the regulations, there's two different sets of regulations. One set of regulations that govern the I-526 petition, and a different set of regulations that govern the I-829 petition. And for source of funds, the I-526 petition is what imposes the requirement on investors to submit affirmative evidence establishing their lawful source of funds. So for all of you on the call now that already filed your I-526 petition, it may have been many years ago now, but you'll go back and remember that your lawyer probably asked you, oh, you need to give me all this evidence to prove that the money came from lawful sources. And that was to satisfy this regulation that requires that evidence as part of the I-526 petition. The I-829 petition regulations don't include that same set of requirements. What they include requirements that you show that the jobs were created in your project and that you kept the money invested. But the only language that deals with source of funds is this language there that I quoted on the slide, which says that the government is only supposed to question your source of funds at the I-829 stage if it becomes known to the government that the investor obtained the funds through other than legal means. So in other words, the regulation is basically, the way we read it, imposing a limitation on the extent to which the government can question lawful source of funds at the I-829 stage. And then there, of course, is sub-regulatory guidance. There's the USCIS policy manual that discusses source of funds, again, mostly in the context of the I-526 petition, and the internal guidance that we'll now turn to. Because as we'll see, the agency's practice does not necessarily line up with the regulatory framework that is binding. Okay, next slide, please. Okay, so what did we learn through this FOIA litigation, this Freedom of Information Act litigation that we did, and from our experience now in representing individual clients? So the first important takeaway is based on the training materials that we've now uncovered through the Freedom of Information Act requests, we can see that the training manuals that individual adjudicators have in front of them when they're learning how to adjudicate cases is basically the same for adjudicators that are in charge of adjudicating I-526 petitions and for adjudicators that are adjudicating I-829 petitions. There are, of course, some minor differences, but the basic standards that are quoted in those training materials are basically the same for the two sets of training materials. And what that tells us is that adjudicators are not really being properly trained, from our perspective, on this distinction between the I-526 and the I-829 stages. Now, that doesn't, of course, mean that adjudicators are requiring that I-2-9 petitioners affirmatively submit new evidence as part of the I-2-9 petitions. But what it does mean is that when adjudicators do raise issues about source of funds at the I-2-9 stage, and they are very much doing this in a number of cases, the adjudicators are imposing a requirement on investors that they basically reprove, as if it were an I-526 petition, that their funds came from lawful sources. So you see language in the request for evidence and notices of intent to deny that are being issued at the I-2-9 stage that say that the agency is conducting what we call de novo review of source of funds, and that the burden is on the investor to prove that the sources of funds are lawful. And that if the agency has questions about the source of funds, that those questions are enough to deny the I-2-9 petition. They are not quoting that, they're not applying that requirement, again, as we see it, that the government have affirmative evidence or affirmative knowledge that the funds were unlawfully sourced before raising questions about source of funds at the I-2-9 stage. Now, we believe that that's a legal error on the part of the agency, but investors need to be aware that the agency is applying fairly close scrutiny when they believe that there's an issue to source of funds at the I-2-9 stage. And this is a trend that we've noticed and that other attorneys in the EB-5 space have noticed. And it's becoming, I think it will become an increasingly significant part of I-2-9 representation of investors like yourselves in I-2-9 petitions. Okay, next slide, please. So one of the areas that we're seeing that USCIS is raising in the context of I-2-9 petitions on source of funds is something I alluded to earlier on the call, which is this new policy of scrutinizing informal value transfers, or what are sometimes called currency swaps. And like I said, I mean, immigration practitioners that have been in the EB-5 area for a while, all really noticed this happening starting around 2017. And, the Freedom of Information Act that we filed, the request that we filed, really kind of proves this to some extent. And here in the slide, I've quoted an email that we were able to uncover through the Freedom of Information Act litigation that shows it's from a USCIS official to another, or to a group of agency officials. And they discuss the, quote, new direction that the agency is moving on cases that involve currency swaps. And in the FOIA materials that are up on our website, you can see some of the draft language that they proposed to adjudicators for requests for evidence that involve currency transfers. And basically, to kind of summarize what is happening, they're asking in cases where an investor has used a currency exchange, they're asking not only that the investor prove that their money came from lawful sources, but also that any money that the currency exchanger used came from lawful sources. So it's not enough for the investor just to show, for example, that the real estate that they originally purchased came from lawfully sourced money, and therefore that their EB-5 funds were lawful. They also, if they use a currency exchanger, have to show that the currency exchanger's money, the US dollars that currency exchanger kept abroad outside of China, that money also came from lawful sources. So their USCIS is asking for a laundry list of evidence about that third-party currency exchanger. And one of the difficulties that this presents to investors is that if the exchange happened many, many years ago, some of that evidence may no longer exist. And so this is proving problematic for some investors that are being hit with these requests at the I-2-9 stage. Okay, next slide, please. The other major area that we're seeing more and more of now, and that has, again, some validation in the Freedom of Information Act materials that we uncovered, is that USCIS is targeting what USCIS deems to be quote unquote unlawful entities. And this again is from the Freedom of Information Act materials that we uncovered, that they've established what's called an unlawful entities working group. And this working group, we filed a FOIA request to uncover more information about it. But what's clear is that USCIS is taking a very keen interest in money that was sourced from companies that the agency does not believe were engaged in lawful activities. So these are not companies that were fundamentally that their core business was unlawful. So it's not like that these companies were the purpose of the corporation was to engage in unlawful activity. Rather, the agency believes that based on either materials in the public record or based on U.S. congressional reports, or frankly, changes in the political dynamic, that these companies are not in the good graces of the United States. The agency is issuing source for evidence and notices of intent to deny at the I-829 petition stage for investors that source their money from companies that the government is targeting. And we know for sure one of them is Huawei. There's no question about that the name Huawei appears quite clearly in some of the slides that we obtained through the Freedom of Information Act requests. Even though it's the world's largest telecommunications manufacturer, and the government believes, based on certain allegations that have been leveled against the company, that any funds that were sourced from employment at Huawei are unlawful. Whether or not the employee, had anything to do with any of the allegations against Huawei, which we again believe has overstepped USCIS's authority, especially at the I-829 stage, to investigate funds, because they're issuing these requests for evidence and notices of intent to deny in cases where there is no real evidence that the individual investor or employee had any involvement in any of the alleged unlawful activities. But this is not just Huawei. This is also being applied in other cases where USCIS cites some reason to believe that the company engaged in unlawful activity. So that's another clear trend that we've seen, and it has support in the Freedom of Information Act materials that we uncovered. The fourth takeaway is that USCIS has become extremely sophisticated in its source of funds analysis. And there's many examples that I could give, but I put here just 3 of them. One is that we know that USCIS is now scrutinizing non-immigrant visa applications for inconsistencies in employment history, for travel history, and education that would create reasons for the agency to deny cases. What this means is that certainly before any investors file an I-526 petition, it's really important to look at the employment history that investors used on any visitors visas or other types of non-immigrant visas that they may have filed before they submit the I-526 petition. Because if there's any discrepancy in the employment history that was listed on a prior visa application and the employment history that's presented as part of the source of funds analysis, for example, on an individual's resume, then that is something that could be flagged. And in many cases, it's not even a real inconsistency. We've had to argue in some cases, pointing out that there's different ways to to spell the same company name in English, where a Chinese company can sometimes have a literal translation, and it can sometimes have a more artistic name that uses English words, and that's not a real inconsistency. That's just simply something that has to do with the way translations are done, but it's something to be aware of. The second example is that we know that USCIS is now become much more sophisticated in what databases are available in the local country. So they are asking for very specific types of documents from very specific offices within the different, within China, for example. For example, the Exit Entry Bureau. They're specifically requesting evidence from that specific bureau, which is something they never used to do. But now they've really gained some expertise in what the local agencies are that would have records, and also what are the databases that they can search online, even if it's in Chinese. And so you're seeing immigration attorneys are seeing much more detailed requests for evidence on source of funds. Now, this is mostly in the context of I-526 petitions, but there's no reason that they couldn't apply those same tools at the I-29 stage as well. And the last example of the sophistication that the agency has developed is, again, out of this whole change in policy regarding currency swaps. And we know that the agency has deployed what is called an IVT tracker, which is basically a database that USCIS has created to track who are these third parties that are engaged in currency swaps. If a company has done, I think it's more than 5 currency swaps, then they get placed in this database, and they are flagged anytime an investor uses this third party to exchange currency, because the agency wants to see, well, what is the volume of transactions that these third parties are engaged in? Because if they're transacting many millions of dollars, then there better be, from the agency's perspective, there better be a good reason why that company has that volume of US dollars sourced lawfully outside of China, because otherwise the volume doesn't make sense, or may not make sense depending on the nature of the business as presented in the petitions. And this we believe is one of the main tools that the agency is using or has used over the past several years to really go after currency exchanges that use third parties that have a heavy volume of swaps. Okay, next slide, please. And I guess the last point that unfortunately has to be raised is that it's pretty clear that USCIS is emphasizing, in particular, Chinese investors and China-related issues. And this slide here is that you see on the screen is from one of the trainings that we uncovered through the Freedom of Information Act that was used to educate new adjudicators within the Immigrant Investor Program Office on adjudicating EB-5 related matters. And I think the slide speaks for itself, where the title of the slide is "The China Threat." And then there's a series of quotes from government officials, US government officials, that focus on the Chinese government's alleged theft of technology, of alleged authoritarianism, and you can read the quotes there. You don't need me to read them. But I think this unfortunately reflects a clear the perspective of the agency in adjudicating these cases. And so, I think that means, as a practical matter, although there's no law that says this, that the burden is going to be more difficult for some Chinese investors to convince the agency that they're not part of this quote unquote threat. And that's the unfortunate reality. We certainly don't agree with it. We think it's wrong, and we believe that it's unjust. But that is the reality of the situation. And I don't want to leave everyone on this pessimistic of a note. So let me just discuss one other.
Let me add a couple of things though yes. This is John Pratt to expand on that. First and foremost, we're only U.S.-based immigration lawyers. We cannot comment or provide an opinion on capital transfers from a country or outside or it complies with its laws. For example, China, Vietnam, or any other country. We are not Chinese or Vietnamese attorneys, so we're U.S. immigration lawyers only. The second and foremost, obviously, some of the information that we're sharing is information that is not just merely opinion, but it's based on records we've obtained through, as Edward documented through the Freedom of Information Act. The presentation is not about to scare people but it's just to understand the new realities. In addition to that, I think it's important to understand the realities of how EB-5 has evolved over the years. And in order to understand what's happening with adjudications at the I-9 or pre-RIA or the pre-new EB-5 law, and how the new EB-5 law addresses some of these issues. The new EB-5 law recognizes that national security is a basis to determine EB-5. So what we've seen is also a movement whereby different law enforcement agencies are embedded or are within the EB-5 USCIS unit. So the idea that the USCIS or EB-5 is acting independently of other agencies in the government is, I think, naive or is not accurate. So obviously the United States government, as a matter of policies, has identified that immigration and EB-5 is or merits higher scrutiny. And this is why they're obviously using different mechanisms. Checking if you on a tourist visa said that you were a photographer, and on an investment visa you said that you were a manager for a company. So they're looking for inconsistencies, they're looking for vulnerabilities to basically do what they call higher vetting or extreme vetting. So those are a few things that I just wanted to point out again, that our comments are strictly and solely based on U.S. immigration laws and how you apply for EB-5 or how you qualify for the EB-5 employment-based category as our focus is here today. And I think that also that highlights two issues. The investor that invested many years ago and is at the petition to remove conditions versus an investor that wants to make an investment today. I think that the investor that wants to make an investment today needs to understand or recognize that you need to have a presentation. For example, we use forensic accountants, we use foreign lawyers, we use different type of things to try to make an application stronger and satisfy U.S. law. That is different, for example, where someone invested in an I-526 7, 8 years ago and got the conditional green card 6 years ago. And at this A829 stage, at the removal of those conditions, have to prove something else. And again, some of the trends that we've seen that Edward pointed out is those individuals removing conditions, for example, where the U.S. government said your income is lawful. You were an employee of Huawei, no problem. You showed us through tax returns and otherwise that you were an employee and you got wages and that's how you got your capital. And the U.S. government said on the approval of the I-526, you're approved. and the US government gave you a green card based on that investment and said you're approved. Those cases are now being re-adjudicated. They're being decided, as Edward said de novo, to say, well, we now know that Huawei is a bad company in our eyes because it engaged in some wrongdoing in our eyes, and your income is unlawful. Those individuals have certain protections, certain rights, and obviously can get proper counsel to try to defend their cases in different contexts in immigration law and defend their green cards. So I think it's important, again, to have those distinctions of, are you an existing investor that needs to remove conditions? And for example, now, because of the knowledge that we have, we've identified weak areas sometimes that we can advise people on how to make it stronger. And that sometimes is very complex because it involves using foreign accountants and foreign lawyers to explain also the laws of the country. And immigration has been shifting their adjudication or how they decide cases. So I just wanted to point out some of those things. And again, I'll just simply stress that all we're opining on is U.S. immigration laws. We cannot opine on anything else since we're not competent and it's beyond the scope of our presentation and our expertise.
Great. Yeah, the last thing, yeah, just to echo John before we open it up for questions is, there are pretty robust protections built into the law for removal of condition stage. So if the I-229 is ultimately denied, there are administrative mechanisms to seek reopening or reconsideration from USCIS. And ultimately, if the person is put into a removal proceeding, the case can be litigated in front of an immigration judge. And there are pretty robust protections in immigration court to try to defend your rights, as John alluded to, both in fighting the I-229 and potentially seeking other forms of relief. So there are it's not like investors will lose all of their rights overnight based on some of these trends that we're seeing. But it's important to be aware of them and to be prepared to fight them in case they crop up, in your individual case. So with that more optimistic note, I'd like to move to the next slide and open up for questions. The one final thing before we do that, we'll be available for about 45 minutes more, but at 10:30 p.m. John and my time, we'll have to log off. So or our answers will no longer be coherent because it'll be too late for us. So with that, yeah.
Let me say just one thing. Obviously, as Edward indicated, we cannot answer case-specific issues if someone desires a consultation, because obviously each case is different. Each case has to be analyzed properly, and each case has to be analyzed in terms of what the lawyer can do, what the law firm can do, what are the person's rights, what is the proper evidence, etc. So that requires a proper consultation, and we are obviously we have our contact information that if you desire to have a consultation with us, we can certainly do that. And after a consultation, if a proper scope of engagement or representation, whether it's a I-229 or if there's a denial or a review and application, then can be discussed of how our firm and our attorneys could be engaged or retained or hired to help you in your immigration matter. Having said that, I think we'll just turn it over for a Q&A or question and answer.
Okay, thank you so much, Pratt and Ramos. So we're going to move to the Q&A section. So we have collected some of the questions from our colleagues, and they collect questions from the investors, and I will present their questions to you guys. Just give me 1 second. Okay, yeah, so there's a question from the back end. So the first question is going to be, what should our Chinese investors do before they submit to, A29? Is there anything they can do in advance? You have any suggestions or any solutions?
I can answer that. Oh, I can answer that generally, and John, you can jump in. I mean, I think it's worth reviewing before you file the I-29 petition. It's worth reviewing the I-526 petition again to see what was included on source of funds, and especially if it was filed a long time ago, whether there were currency exchange issues or money sourced from companies that might be deemed unlawful entities under current USCIS policy. And I look to see whether there's evidence that might disappear later on that could be obtained now. So, for example, in the case of a currency exchange, maybe that third party is still available, and maybe you could still proactively request some documents from that third party. Now, I wouldn't necessarily think it's a good idea to include them as part of the I-29 petition, but at least you have them in your possession in case USCIS asks questions about it later, where some of those records may no longer be available, 3, 4, 5 years down the road when the I-29 petition finally gets looked at by an adjudications officer. So I think, it's not harmful to be proactive in that respect. John,
just to follow up on that, I think it's a mistake to file an I-29 without having a thorough review of the initial source of funds that was submitted on the I-526. Obviously, the adjudication standards have shifted. So, for example, if my investment came because I was an employee of Huawei, well, we know they're looking at Huawei. It depends on what was your position at Huawei. How long did you work? When did you work? What was your income? Where were you stationed? There's a lot of different factors that may play a role into it and may or may not be irrelevant, but you need to know that. For example, if you used an exchange, meaning you gave the equivalent of RMBs to someone in China and some Hong Kong company or Singapore company send the equivalent of US dollars to the United States, then you need to start proactively trying to, as Edward said, through use of foreign lawyers to explain the legality of the transaction, through accountants in the home country and in the United States to get the proper bank accounts and the proper documentation, or to prove the absence of it. There's a regulation that requires that if immigration asks for the evidence, and the evidence not produced, that regulation empowers USCIS, and we've seen it now for the first time in a case where they said you didn't produce what we asked for, therefore we deny you. But proving the absence of it because of the length of time, etc. So the one big lesson that I think I want to impart on everybody, if you're going to file an I-829, get proper representation and have a thorough review of that application to forecast, based on these new trends that we've learned, the likelihood of winning and the likelihood of submitting additional evidence if requested by USCIS to increase your probabilities of winning the case.
Okay, thank you so much. So the next question would be, so let me translate to Chinese first, so our investors can understand what I'm saying. 下一个问题是，如果829因为资金来源问题被拒，想找你们咨询，费用是怎么样的？你们有做过什么成功的案例吗？So if my 829 is rejected, what is your litigation fee range? Can you share some successful cases, please?
Yes, I mean, as far as the fee range, it's based really honestly on a case-by-case basis. That's where you have to have a consultation. Some cases we charge by the hour, some cases are differently, but US law establishes the following. If USCIS denies my I-829, they did not approve it. The law says that I have the right to, again, seek approval of that I-829 in front of an immigration judge. So the application is renewed in front of an immigration judge. The immigration judge then has the ability to take evidence, to take more documentation, to take witnesses. We have the ability to maybe ask questions to USCIS officers and ask for depositions. So there's a trial in front of an immigration judge in an immigration court. So that is an ability to then obviously present that my money was legitimate. What the government is asking is inappropriate. The government is overstepping its bounds. And for example, obviously presenting new evidence that you could satisfy, including the fact that your money was properly used, right? My money was properly used and created the jobs. So if you meet all those requirements, the immigration judge can grant it. Now, the immigration judge is set up in a different office. It's not a longer USCIS or USCIS. It's a different agency within the United States government. If the decision is not positive, you don't win it, you have an administrative appeal before something called the Board of Immigration Appeals. So, you know, a lot of people worry that, oh my God, USCIS denied my I-9. You know, I'm illegal in the United States. No, US law is very clear that you retain your green card and the rights to travel, work, and everything related to a green card. Your kids can still go to school as green card holders. You can still travel internationally as green card holders. You can still work as green card holders or lawful permanent residents until there's a final administrative order of removal. When does that happen? When the judge denies me? No. When the Board of Immigration Appeals, that appellate court, decides it. If they decide it in your favor, you get your green card, you get an unconditional green card. If they don't decide it in your favor, then that's when you lose the rights to have a green card, even though you can have a further appeal to federal court. The other thing I want to stress is that if you ever put in proceedings in court because they deny your I-829, there may be other remedies that are, it's very complex to explain, but there may be other remedies that you could try depending on the length of time that you've been in the United States, depending if you have other family members that are US citizens or not. The last thing I like to say is that some people, for example, have other ways to get another green card. And in a number of cases, we've defended it that way, whether they made a new investment or they had a daughter that eventually got married to a US citizen. So there's other ways that you could try to defend it. Bottom line is this: we have succeeded in a number of cases, including some of the issues that we've had, both either in federal courts, but more often than not now, if you challenge in federal court an I-829 denial, there's a possibility that you fight the case in immigration court. Let me highlight one example. They placed the person, they said that they denied the I-829 because they alleged that his funds were unlawfully sourced, Chinese national. It was not Huawei. It was another technology company, software company. Eventually, there were other issues in the case, but ultimately, we forced the government to submit more evidence, not just that they wanted to make a new decision based on the evidence, but if they had more evidence, basically. And the government eventually gave up, and we got dismissal, or we succeeded in the court to allow the person to remove the conditions and get his unconditional green card. We succeeded in different cases, representing investors in those removal proceedings, and Edward and I have worked in a lot of those cases. So we have a pretty good track record, but each case is different and it needs to be evaluated independently.
Thanks, Attorney Pratt. And the next question is going to be what is 下一个问题是，对于新的EB-5投资人来说，如果他们依然需要换汇机构来获得美元资金的话，您有什么建议吗？What is your suggestions for the after RIA investors if they still need currency swaps?
That's a good question. It's one that I think is a little bit hard to answer in general terms. But I mean, I think you need to really sit down very carefully to make sure that all the new post-RIA requirements are satisfied, particularly with respect to showing both that the investor acquired their money lawfully, but also that the third-party currency exchanger acquired their money lawfully. And now the RIA includes some language that specifically requires that sort of evidence as a matter of the statute itself. And so there's no longer an ability to argue that USCIS is overstepping its bounds, because now the law itself says that you need to provide evidence for the lawful source of the third party. And so, I think you have to, in some sense, treat the third party as if they were the investor themselves, and think about all the evidence that the investor would need to present. That third party will also need to present unless they're a licensed currency exchanger. And even then, we've seen cases where USCIS has questioned the third party's lawful source of funds or the path of funds. The path of funds is a little bit different than the source, but the path is the idea that every single dollar that ends up in the bank account of the U.S. business has to be traced back every step of the way to a lawful source. And we've also seen that the agency has gotten hyper-technical about that tracing process, that if there's any gap that's not fully explained, through objective evidence, not just a declaration, but through objective evidence, then those cases are being questioned. So I think there's no easy answer to that question, but it really, as John was explaining earlier, it really requires a very, very high level of detail. And in some cases, attorneys are now using forensic accountants, for example, from the very beginning to trace the funds and ensure that the process that's being used can be fully documented. And the advantage of doing that at the beginning is that you have some control over the path of funds. You can structure the investment in such a way that the path of funds and the source of funds can be very clearly determined. And that's I think something that's increasingly important given some of the sophistication that I was discussing earlier about the agency's analysis of source of funds. And one last point on that is that one of the things to be careful about, I think that's important, is this idea of commingled funds. Because if you have, in our daily lives, we use bank accounts that have money flowing in and flowing out. But anytime you have a bank account like that, where the money passes through such an account, it creates a nightmare for the sourcing, because now you have to, because money is fungible, it becomes very difficult to say where the money came from if you have even $1 in that bank account. Well, where did that dollar come from? And then if it came from some other source, some other bank account, then where did all the money from that account come from? So it creates this nightmare of cascading sources that then have to be proven to establish that the money was deriving from lawful sources. Again, under the way USCIS is applying it in certain cases. So
let me just expand on that a little bit. And from my point of view, obviously, it may be a lot of hard work initially on an RIA case, but that will solve a lot of problems, specifically if you use, for example, a forensic accounting report and evidence. Because the adjudication may occur months, if not years later, but you corrected it at the beginning. It's a lot harder, for example, the I-829, because you're trying to fix something that happened many years later. So my advice would be obviously to look at what the IRA requires, tax returns, personal, banks, etc. So to have the core documents and the core information that the IRA requires, and then to use a professional, a forensic accountant or an accountant in order to do that tracing of the path of how money moved. And a lot of cases where we advise people to set up a new bank account where the 800 800 investment or 800,000 investment or the 1,050,000 investment is sitting there. So it doesn't land where the other funds are there. So we don't get into this commingling issue that Edward said. But the other thing that I just wanted to say is, again, and we've said forensic accountant for a number of times, if you use experts like a forensic accountant and it's in the record, and then you have to go in front of an immigration judge, it's no longer the lawyer simply making an argument. That is evidence. And if an accountant says this is reasonable, this is not reasonable, this is what's proven, you increase the probabilities of winning your case. For example, in some of the Huawei cases, we use forensic accountants that have been used by the United States government in securities and exchange investigations and EB-5 and elsewhere. We've used former top prosecutors to opine on the issue of, if I'm an employee for a company, when can my wages be unlawful? Specifically, if I'm Huawei. So you need to, unfortunately, if it gets expensive in some cases, but you need to have that type of evidence in order to increase your probabilities of winning. And again, if you're doing an RIA type case, meeting some of the basic requirements of the IRA in terms of tax returns and so forth is at the minimum. And then obviously determining how that money moved. And it's specifically challenging for Chinese investors because they cannot simply have $800,000 sitting in a bank account in China and send a wire to the United States because of currency restrictions and otherwise. Again, we cannot comment on the lawfulness of getting capital out of China. What we're saying is for U.S. purposes, the U.S. is scrutinizing how those funds are exported from China and to prove who did it, how it was done, the mechanisms used, are they licensed or not. And the more formal they are, whether they're licensed operators in their countries, etc., the higher the probability of succeeding.
Okay, thank you, attorneys. So the next question will be, 关于加密货币有更多详细的案例吗？Can you please give us more details about the cryptocurrency used in the EB-5 cases?
Yeah, not so much, just because there's not a ton of guidance. But there is a policy memo that's posted up on our website, the FOIA litigation website, that discusses their overall kind of, not policy, but some of the considerations that they look at when cryptocurrency is involved as part of the source of funds. Certainly, this was an issue that the government itself had flagged. For a time, all cases that involved cryptocurrency were put on hold. Every single one was put on hold until the agency issued some internal guidance on how cryptocurrency cases could be adjudicated. We know from the FOIA, the Freedom of Information Act request, that at least one has been approved. There's email exchanges in the FOIA production, again on our website, where the officers were kind of half celebrating that they were able to adjudicate one and get an approval out. But you'll see, if you look at that example, that the documentation provided was extensive. And to touch on a point John raised earlier, that case involved experts, because one of the things that they discussed in the memos involving cryptocurrency is that one of the features of cryptocurrency is that it's very difficult to tell who owns the funds, because there's some, 25-digit string of alphanumeric characters that define what the wallet is, and it's not attached to an individual person. And so how do you prove that those were your funds, not someone else's funds? So they had to bring in experts in cryptocurrency to explain how the whole process works, which is a little bit above my pay grade, to be honest. All of the tokens and keys and all the stuff that goes into it. But yeah, I mean, if you've used current cryptocurrency, or God forbid you're thinking of using cryptocurrency to make a new investment, that guidance is posted up on the FOIA webpage that we have.
The only thing I would add to that is, obviously, cryptocurrencies present certain problems, not only for the agency but for the attorney, because we're not experts, and the whole concept of cryptocurrency obviously was some issues regarding traceability, and those complexities of traceability are present in before USCIS. So the other thing I will simply add is whenever USCIS is offered a complex new fact pattern on anything, including my capital, you're forcing the agency to make some policy decisions and some judgment calls that may not be in your favor. So what I would simply caution is there's a more traditional way to prove and source your capital. Use it rather than using a more novel approach. And if you go with that novel approach or that sophisticated approach, have these experts, have these declarations, etc. Because just like we are not experts in cryptocurrency, USCIS are not experts in cryptocurrency. And what you don't want to do is have a file that is not properly supported with expert declarations and otherwise and evidence for the adjudicator to get it wrong. Even if they don't want to do anything bad, they may just get it wrong because it's complex. So, you know, sometimes we as lawyers tend to do just don't make it complex, make it easy if you can. If you cannot, then obviously what, you know, as Edward pointed out, build the record properly to explain it and educate USCIS that you are the owner and that the funds were lawfully created and lawfully moved through the system, what we call the source and the path. So you can have an increase of probability of winning.
Okay, thank you, attorneys. So the next question will be from the chat box. EB-5投资人投入资金转款途径的问题，如果投资人的资金在中国汇给多个中国朋友的个人账户，这些朋友汇给EB-5投资人的账户会不会有问题？EB-5 investor funds transfers channel question. If the investor funds in China to the personal accounts of several Chinese friends, these friends to the EB-5 investors account. So will there be a problem?
John, I don't know if you want to take that.
Well, when I started in EB-5, that was the traditional method. You gave 10 friends in China $50,000, and the 10 friends in China would eventually send to a bank account in Hong Kong and coalesce into one bank account and send it out. I have not seen that mechanism used. We don't use that mechanism for when we're doing our own I-526s. Because the problem that you could get into, and I have not seen it lately, but the problem we could get into, who was the friend? What bank account did the friend put the $50,000 or the $80,000 that the investor gave them? Were those funds commingled with other funds that this friend had? How do we know that the funds that the friend had in that bank account were lawfully sourced himself? Because this is the commingling problem. If I put $100,000 of clean money, but $20,000 of bad money were there, they think that $20,000 of bad money tainted the whole thing. They're all dirty now. So if you're going to use that mechanism, I would caution to again use accountants and determine where the money landed. Was there more money there? Who was the account holder? Can you provide documentation on that account holder, etc., so you can do it? And again, we're not commenting on the lawfulness of that mechanism under or the Chinese law. We're obviously only commenting on whether USCIS will recognize it as a valid capital investment for EB-5 purposes. So I would be skeptical whether that mechanism would be just completely accepted like it once was in the beginning with the EB-5 industry with Chinese investors. I don't know if you want to expand on something, Ed.
Nope, I don't think so.
Okay, thanks, attorneys. 由于时间关系的话呢，我们现在的聊天窗口问题就截止到如此。如果后续大家还有其他疑问的话呢，可以在我们会后去联系我们的专员，或者您也可以联系屏幕上方律师的信息。我们接下来的下一个问题是，投资人资金在中国汇给朋友的个人账户，朋友在海外汇给 EB-5投资人的美国账户，这样会产生问题吗？So the investors' funds are transferred to the personal account of the friends in China, and the friends' US dollar is transferred to the EB-5 investors' US account directly. So will there be any cost problems?
Well, that sounds like the currency swap situation that we were discussing, right? So where the money goes from the investor's Chinese bank account in China to the friends or the third party's bank account in China. And then in exchange, the third party or the friend uses US dollars that are sourced outside of China to transfer those funds into the United States. So no money actually leaves China, but there's a swap. And this is what we've seen in the Freedom of Information Act requests and the experience of EB-5 attorneys is that now, if such a mechanism is used, the government wants to see that not only that the investor's money was lawfully sourced, but that the money from the third party was lawfully sourced, whether it's a friend or whether it's a company or whether it's another entity. They want to know that the money that the friend used or the third party used, the US dollars that were held outside of China, where did they come from? Because if they believe that that either the third party can't prove where the money came from or that the money was not lawfully sourced, that they're not going to accept that as a valid, as lawfully sourced US dollars that were invested in the US business. And this is exactly what was presenting a problem to the I-829 people, because when they invested the money before 2017, this issue was not on people's radar because the government wasn't really asking about where did the third party get the money from. That's definitely changed now. So you have to be very aware of it.
Correct. Let me again just expand a little bit. And let me use an example. So I give my friend 800,000, I give one of my friends in China $100,000 in RMBs equivalent. That friend has a bank account in the Bahamas or in Denver, Colorado, in the United States, $100,000, and he sends it from that bank account into the new commercial enterprise or into a bank account that I own in the United States to then put into the new commercial enterprise. And 10 friends do that, 100,000 each, 800,000. The United States government will then say, friend number one, where did you get the money to have $100,000 in the Bahamas or in Denver, Colorado? We want to see his tax returns. We want to see how he got the money into that bank account, whether that bank account got commingled with other assets. So they're asking a series of events. Now, the United States government is also not stupid. Eventually, what they realized, and I can give you one example, there was a company in a third country where this would happen. And eventually, the government realized that, wow, this company didn't send one $500,000. It sent like 100 $500,000. So when you would look at that kind of volume, they became very suspicious. How could a company have that much money to be sending? That's where they did the IBT tracker. They started saying which companies are being used, what are the entities, what are the names. So a lot of times, obviously, people use agents or other people that are assisting them in this, and they don't know who the person is. Again, I would caution each investor not to know who the trend friends are and so forth. But USCIS is asking for license money exchangers and a couple of other requirements. You really need to have a discussion with the lawyer that will be representing you if you're making a new investment to make the best decision of what mechanisms are available in order to try to satisfy these new criteria. But it's certainly, if you're using that mechanism, you, in my view, and please chime in, Ed, you will face scrutiny if you use that mechanism right now to make your investment.
Okay, thanks, Attorney. 我们接下来由于时间关系的话呢，我会挑选3个问题来进行回答。其余的问题的话呢，我们可以在会后联系我们的彼岸专属顾问，或者您也可以扫描右方的这个小助手二维码微信，然后呢，我们会有专员来与您和律师取得联系，来帮助您解答的。Okay, so the next question is how the law firm can do if the currency was from the third-party exchange in Hong Kong, considering the attorney described above, or say if the investor hit any of the issues the attorney mentioned, what the law firm can do for the investors.
Well, I think the law firm, it's not a very specific answer because it's a pretty general question, but I think the law firm can evaluate, what is the evidence and that can support the lawfulness of both parties involved in the transaction. And again, there's going to be things that the attorney can't do, right? I mean, if one of the issues was this a lawful transaction within the scope of the countries where the exchange happened, that's going to require the participation not only of the U.S. immigration lawyer, but potentially also, experts in the laws of the local jurisdictions. Because as John alluded to, one of the things that USCIS has asked about in these types of cases is to prove to the agency that this transaction was permitted under the local laws of the jurisdiction. Did the local jurisdiction require a license if you're a currency exchanger? If so, did this transaction fit within the requirements of that local jurisdiction's laws? And some of that requires coordination with other experts. Because under US law, a question about a foreign jurisdiction's laws is a question of fact, because the US, that has to be established through expert testimony. So it can start to get complex, but I think that, that would be the role of the attorney, is to try to coordinate that and make sure that, that all of the appropriate experts are aligned to the appropriate problems, and that it's all presented in a manner that makes it as easy as possible for USCIS to understand what the actual source and path of the funds are.
Let me just add to that, obviously, and I'm just restating a little bit different. The first part of what the law firm can do is study the case that was presented and the facts that existed. For example, did I give the money to someone in China? Who was that person? Was it an individual person or was it a company? How much did you give them? Did the money leave China or did it stay within China? Is there a contract between the person that you gave the money to? And then you need to also look at who was the third party exchanger in Hong Kong. Was it a company? Was it a person? Was it a licensed exchanger? Was it a bank? You need to determine what kind of contract exists that they are sending the equivalent from that entity into the United States. Did they have the tax returns? If it's a person, if it's a company. So you first need to analyze the facts. What happened? Once you analyze the facts of what exactly happened, who was involved? How were they involved? Did I give the money in China and the equivalent came out of Hong Kong? And again, who was it? Was it a company? Was it a licensed exchanger? Was it a bank? Once you determine the facts, then you can then try to hire the proper experts, whether they're foreign accountants, foreign lawyers, to show the lawfulness of it, the legalities of it, whether the proper contracts exist. And then obviously, then sometimes you can engage forensic accountants here and other experts in order to prove that everything that happened in how that money went from investor generating the income to the actual investment into the new commercial enterprise complied with U.S. immigration laws. So again, to reiterate, the first is an analysis of what happened, and then building the team and the resources in order to document that it complied with U.S. immigration laws to try to increase your probabilities of winning.
Okay, thank you, attorneys. So next gonna be the last question. 当以美国移民局审核526的时候，已经要求 RFE 要求第三方换汇人的资金来源证明。如果成功的话，是不是就代表829递交就没有问题？So when USCIS audits the I-526, they already requires the RFE for the proof of the source of funds of the third-party exchanger. Does it mean that there's no problem with the 829 stage?
Unfortunately, no, it does not mean there's no problem with the I-829 stage because as we discussed a little bit earlier during the presentation, USCIS is scrutinizing I-829 petitions for source of funds. So what that means is that when they're adjudicating an I-829 petition, in some cases, they'll go back to the I-526 petition, look to see what the source of funds was. And if the presentation does not satisfy the officer based on the practices that those officers have been trained in now under current guidance, then they've been issuing RFEs and in some cases notices of intent to deny or even denials, that go after those same issues. So that's what we were saying, is that you have to be prepared to address those issues at the I-829 stage if they're raised. If possible, you want to try to know whether there's going to be a problem ahead of time. Don't voluntarily raise the issue because there's no requirement that you submit source of funds materials with the initial I-829. But if it comes up in the course of the I-829 adjudication, then you absolutely have to be prepared to address it. And that means two things. That means, number one, pushing back against the legal policy that they're applying, which is they're, in our view, incorrectly suggesting that source of funds can be adjudicated de novo, or like as if it were an I-526 at the I-829 stage, pushing back against that position legally. And secondly, if it's possible to address the underlying issue, then to do that as well. That the difficulty is that if you're issued an RFE or a NOID, notice of intent to deny, you don't have very long to respond. In the case of an RFE, it's about 3 months. In the case of a NOID, it's about 1 month. And those deadlines can't be extended. So it's helpful to know ahead of time whether you think there could be a potential problem. And if there's not, then great. And if there is, then you're prepared to address it.
Let me address a trend we saw as well. Everything that Ed is 100% correct. You need to know what's in your I-526 to forecast the likelihood of getting your I-9. Just because your I-526 had that evidence, or it was requested in a request for evidence or a notice of intent to deny, and you survive it, doesn't mean you're going to survive it or you're going to be successful at the I-9. But the trend we've seen is regarding writs of mandamus at the I-9 stage. There's a lot of investors that feel that, it's incorrect for me to be waiting 3, 4, 5, 6 years for an I-9. So I'm going to go ahead and file a lawsuit to get a decision. But what they didn't do with the lawyers is to determine what's my likelihood that I'm going to get my I-829 approved specifically in this circumstance. The best example that I can give you is the initial batch of Huawei denial cases we saw all came from mandamus cases. These were cases that were pending. Lawyers filed a lawsuit saying, immigration, make a decision. And immigration came and said, your income is from Huawei. Now, in the lawyer's defense, when it wasn't known that they were looking at this, maybe the first batch was surprising. But now we know. We've made this materials available to the community at large. Edward and I have lectured on this thing, that they have this entity list. It's not a secret anymore. And that, so we know about Huawei, but there's other entities that we've seen from China and other countries, including the US. There's people on H-1Bs and other areas. So it's important to the investor at the I-829. It's critical, I would say, to work with your lawyer and forecast the probabilities of winning the I-829 specifically if I'm going to be suing to get a decision on it. Because what we've seen is, you want a decision, here's a denial. And it's not retaliation, because a lot of people say, well, they retaliated me because I sued them. It's not retaliation, but you need to determine that a writ of mandamus is to make a decision. It's not an approval or a denial, but you need to forecast the likelihood based on that record that you will be approved in order to determine what your chances of success are of winning.
Okay, thanks, attorneys. So that's going to be all the questions today. 好的，那我们今天的问答环节到此结束了。如果活动结束后您突然想起哪些问题，也不用担心，您可以联系我们的工作人员，或者添加我们的官方微信小助手的微信，我们会有专员来为您解答的。那么再一次感谢我们的主讲人，也非常感谢参与本次分享会的听众们。那同时呢，在这里我们也推广一下我们的彼岸官方账号。我们在微信视频号、哔哩哔哩和 YouTube 以及小红书上都开通了官方视频公众号，您可以在平台上搜索"彼岸海外投资生活"即可找到我们了。也欢迎您多多转发、点赞以及订阅，我们会努力为您带来更加精彩的内容的。好的，那再一次感谢大家的时间参与本次移民分享会，祝您生活顺利，事事顺心，期待与您再一次相见。Thanks, Attorney Pratt and Ramos again. Much appreciated to give us a very meaningful presentation. So if investors would like to consult or share their questions to you, we will definitely forward them to you. Thank you all and have a good night and have a nice weekend.
Thanks so much. Good to speak with you.
We hope the information is useful. Again, it's not to scare anyone. It's simply for everybody to be properly represented and to know how to increase their chances of succeeding and getting their applications approved.
Thank you so much. Thank you. Have a good night.
Bye-bye.